Hello, my name is Jeremiah Anachuna, and this is my land law presentation of Is There a Room for Overriding Interest in Modern Day Title? And I proceed. What is an overriding interest, one may ask? These are interests that binds anyone taking a registered disposition, including a purchaser for a valuable consideration, although they are not recorded on the register, but as a consequence cannot be discovered by inspecting them. The system of land registration was formally introduced by the Land Registration Act 1925. However, prior to this, there was only a voluntary registration for the title of ownership by the legislation of 1862. The aim of this act was to modernize the law and render the sale of land rapid, with the end result being a successful establishment of a title register. The Land Registration Act 1925 is founded on three principles, namely the mirror principle, the curtain principle, and the insurance principle. But for the focus of this presentation, I will be considering the mirror principle and the curtain principle. The mirror principle, as the name implies, states that all interests must reflect on the register, so that a purchaser may know the interest that which he is bound by. The curtain principle, on the other hand, hides this interest, so the purchaser is not aware of this interest in the land, but however is still bound by them. I now go to the problems of this act. One fundamental issue with this act was, under section 70, subsection 1, there were an extreme long list of overriding interests covering different aspects of land ownership. Examples of these interests were easement, both legal and equitable, the right of res quotas under the Limitation Act, and most importantly, was the right of a person in actual occupation. Martin Dixon observes that the fact there are categories of proprietary interest that could bind a purchaser without them being undiscoverable is very concerning. There have been no other section other than section 70 subsection 1 to have received a fierce criticism. The most obvious example is the right of equitable co-ownership stemming from the case of Petit and Petit, whose effect under section 70 subsection 1G of an unwary purchaser was first fully appreciated in the case of William Kleinbank and Bolen. Another is the equitable estoppel easement said to fall under section 70 subsection 1A in the case of Selsteel and Alton, and Ferryhurst Limited and Warside, where the plaintiff overriding interest was undiscoverable because his actual occupation extended to only part of the property. This act gave rise to a number of reasons for which the Law Commission and Her Majesty Land Registry came together into establishing a program that will reform the whole area of the land registration system. And this was what led to the introduction of the Land Registration Act 2002. This act is by far the most concise and fundamental overhaul of the land registration system since its formal inception in 1925. The act, it would seem, aims to direct the trend of conveyancing to a more electronic system for the not too distant future. In other words, an implementation of electronic conveyancing, which was the driving force of this act. The act intention was to simplify and modernize the Land Registration Act 1925 and to make the register a more detailed and accurate reflection of land ownership, i.e., the Miro Principle. This act gave rise to a number of effects arising, which were a reduction in the number of overriding interests. Example, the right of squatters under adverse possession no longer binds as an overriding interest. Also, other overriding interests were phased out subsequently 10 years into bringing into force of the Land Registration Act 2002. Such rights that were phased out were manorial rights, crown rent right, right of franchise, and right of embankment and sea and payment in lieu of title. However, some rights retained their status as overriding interest, but their scope were narrowed down and clarified. Examples of such rights were easement and profit under Section 70, subsection 1A, and significantly was the right of a person in actual occupation under Section 70, subsection 1G. This act was not without its own problems. A fundamental issue with the Land Registration Act 2002 was the act gave no definition for the term actual occupation like its predecessor. And in order for one to ascertain what actual occupation means, one had to go to the cases decided in 1925. Barbara Busk argues that the lack of definition is to give a flexible judicial interpretation of actual occupation, and in doing so to eradicate the harshness of the rule and the policy bias towards protecting the purchaser, and to find a solution to the state of affair of the case. However, in the leading case of William Glynebank and Boland, Lord Wilberforce stated, and I quote, "Actual occupation are words of plain English and should, in my opinion, be interpreted as such." Despite Lord Wilberforce's statement, there were further complexities in ascertaining the relevant time of occupation. In the leading case of Abbey National Building Society and Can, the House of Law stated that the relevant time for determining occupation for the purpose of Section 70, subsection 1G, was at the date of completion of the transaction rather than the date of registration. However, this principle has been questioned in recent case law. Example, in Thompson and Foy, it was questioned whether actual occupation must as well exist during registration in order to be interpreted in accordance to Section 27, subsection 1, and Section 29, subsection 1. In a Mo 2015 case, Southern Pacific Mortgage and Escort, Lady Hale laid a strong emphasis stating whether the Can's principle extends to contract of sale. Another issue arising from this act was that under Schedule 3, the right of a person in actual occupation are excluded from overriding status in two situations. First, when an inquiry is made by the right holder and he fails to disclose the right, in circumstances where he could be reasonably expected to do so. Secondly, when the right holder in occupation is not obvious on a reasonable, careful inspection of the land, and the person who is bound did not disclose or have actual knowledge of the interest at the time of the disposition. Now, this leads to a critical issue. Is the right owner bound to disclose any of those interests or the overriding interest at hand? Martin Dixon argues that would it be fair and reasonable to expect disclosure when one is not aware of the beneficial right in the property? How can one disclose what one is not aware of? Furthermore, Martin Dixon argues that would it be reasonably unfair to expect disclosure when the right owner knows that the consequences of disclosure is losing one's family home? Another issue is concerning the word obvious and reasonable. It is the occupation that is or should be obvious and not the right. Judges will have to determine what obvious is and what amounts to a reasonable, careful inspection. Cases would therefore be determined by their facts, which clearly implies more litigation in the future and an unending overriding interest issue. Why was overriding interest not abolished by the Land Registration Act 2002? The Law Commission gave reasons for not abolishing overriding interest under Section 70, subsection 1. Reasons being, overriding interest provides a means of accommodating rights which can be created informally and where it is unrealistic to expect registration at the time of creation. Also, there are some rights that are pointless or either convenient to register, for which the Law Commission specifically noted short leases. Also, there are rights which are otherwise protected, and it will therefore be unrealistic to expect them to be registered. Example, the local land charges, which are registered at the local land charges register. Importantly, the Law Commission noted that a wholesale abolition of overriding interest might contravene Article 1 of the European Convention of Human Rights, which is the right to a peaceful and enjoyment of property. Then, what can be done in order to reduce or stop the litigation arising from overriding interest? I would propose that there should be an active demand for all overriding interests to be registered for the benefit of both the purchaser and the right owner. Secondly, the land registry should give effect to the mirror principle so that a person's interest can only bind a purchaser only if it is in the register. There should be also a drive and a vast implementation of electronic conveyance, as the better the enhanced way title is registered, the possibility for a more cohesive and a clear system. This leads down to my conclusion. Is there a room for overriding interest? Based on the observation by the Law Commission, one can safely say that there is a room for overriding interest in modern day title. However, this conflicts with the aim and intention of the Land Registration Act 2002. So there is therefore a call to the Land Registry to give effect to the mirror principle and certainty to the whole system of the land registration. Thank you, and this concludes my presentation.